Hello and welcome to Newsreel Asia's We the People, a series where we explain political, economic, social and psychological concepts that help news consumers like you understand the core of the issues that you encounter every day and become more informed citizens. I am Gunjan Handa, and in this episode, I will explain the idea of constitution, what it is, how it evolved, and why it should matter to us as citizens. We have all grown up hearing about the Constitution in history class, where we learned how it was drafted after independence, and in civics class, where we studied how it drew ideas from around the world. We also hear about it almost every day in the news, in political speeches that emphasize its importance and the need to protect its core values. We are told that it protects our rights and democracy. But what exactly is a constitution? In the simplest terms, a constitution is a body of fundamental principles according to which a state is organized and governed. It defines who holds authority and how it is exercised, what limits exist on it, and what rights and protections belong to the citizens. The idea of organizing governance through rules is ancient. The earliest evidence of a code of governance was discovered during excavations in modern-day Iraq by Ernest de Sarzac in 1877. It referred to a code of justice issued by the Sumerian king Urukagina of Lagash around 2300 BC. Although the actual document has not yet been found, historical records suggest that the granted certain rights to citizens such as tax relief for widows and orphans and protection of the poor from exploitation by the rich. Later, around 2050 BC, the Code of Ur-Nammu became one of the oldest surviving written law codes. These were not constitutions in the modern sense, but they represented early efforts to define justice through written norms rather than arbitrary command. The conceptual foundations of constitutional thinking, however, began to take clearer shape in ancient Greece. Aristotle was among the first to distinguish between ordinary laws and what he called the constitution, which he described as the agreement of the offices in a state. For him, the structure of power, who governs and in whose interest, was central to the understanding political life. This distinction between everyday laws and the fundamental organization of authority is at the heart of modern constitutional design. In medieval England, documents like the Magna Carta established a crucial principle. The king could not act purely on personal will. Even the ruler was subject to the law. Over time, this idea expanded. During the English Civil War, political thinkers began openly debating whether monarchs ruled by divine right or whether governments derived authority from the people itself. Sir Robert Filmer defended the idea that kings were appointed by God. In contrast, philosophers such as John Locke, Algernon Sidney, James Tyrrell, and Henry Neville argued that government rests on the consent of the governed. From this debate emerged the theory of the social contract, the idea that political authority is created by people coming together to form a society and that governments exist to protect their rights. Authority in this view is not sacred, it is conditional. In 18th century, Montesquieu deepened constitutional theory by arguing for the separation of powers into legislative, executive, and judicial branches. His insight was that concentrated power threatens liberty and that dividing authority creates internal checks that prevent domination. These ideas profoundly influenced the design of modern democratic constitutions. Written constitutions often emerge at moments of dramatic political transformation. The Articles of Confederation that preceded the American Constitution served as the nation's first framework of government during the American Revolution. The Indian Constitution, similarly, emerged from India's long struggle for independence from the British rule. These movements were not merely administrative transitions. They were collective acts of defining a new political order. Behind all these developments lies the philosophy of constitutionalism. Constitutionalism means that governing is a duty bound by rules, not a privilege exercised at will. It means that power must be limited, accountable, and subject to law. Even authoritarian regimes may have formal rules, but constitutionalism demands something more: the prevention of arbitrary decision-making through institutional checks and balances. Dr. B.R. Ambedkar, the principal architect of Indian Constitution, warned, however a constitution may be, it is sure to turn out bad if those who are called to work it happen to be a bad lot. However bad a constitution may be, it may turn out to be good if those who are called to work it happen to be a good lot. In India, the constitution serves four crucial functions. First, it provides a set of basic rules that allow society to function smoothly and ensure coordination among its members. Second, it specifies who has the authority to make decisions and determines how the government is to be formed. Third, it enables the government to fulfill the aspirations of society and work toward a just social order. In a society like India, marked by deep and historic inequalities, the Constitution not only limits authority, but also empowers the state to take corrective measures to overcome injustice such as caste discrimination. Just as South Africa's constitution was designed to dismantle racial inequality, India's constitution enables efforts to build an equal society. Fourth, it places fundamental limits on government powers, setting boundaries that cannot be crossed. It lays down the rights and duties of citizens and includes the directive principles to guide state policy. Finally, and perhaps most importantly, a constitution expresses the fundamental identity and values of a people. In India's case, a commitment to secularism, democracy, equity, and justice. Why does all of this matter to us as citizens, though? Because the Constitution acts as a safeguard against arbitrary authority. It sends a clear message to those in power. You govern on behalf of the people, not above them. It assures citizens that their rights do not depend on the goodwill of the rulers. It gives us the voice and the legitimacy to demand what we are entitled to as people. It creates mechanisms for accountability and provides legal remedies when our rights are violated. Above all, it shapes our collective identity by affirming shared values of justice, liberty, equality, and fraternity. At the same time, a constitution cannot defend itself. It depends on citizens who understand its principles and remain vigilant. We must be wary of any attempt to promote the supremacy of one community over another or to undermine the principle of equality. Any authority that resists scrutiny undermines constitutional governance. We must also question forces that reject rationality, scientific temper, and the spirit of justice that Constitution seeks to uphold. The survival of constitutionalism requires public awareness, participation, and commitment to rational, democratic engagement. Ultimately, a constitution is more than a legal document. It is a statement about who we believe we are and who we aspire to become. It defines not only the structure of government, but also the values that guide collective life. When we protect constitutionalism, we protect the idea that power must serve people, that justice must remain accessible, and that dignity belongs to every citizen. And that is why understanding the Constitution is not merely an academic exercise. It is a civic responsibility.